Hey everyone, welcome back to the channel. Today we're diving into a topic that's not just a blast from the past, but a potential crisis for the future. Are we really ready to turn back the clock on childhood vaccinations? Picture this. It's the early 1900s, and American schools are like a ticking time bomb, not from violence, but from diseases like measles, polio, and smallpox. Yep, classrooms were a breeding ground for outbreaks that claimed countless young lives. That's why states stepped in and made vaccines mandatory, because protecting the many means everyone has to step up. Fast forward to today, and guess what? Florida is shaking things up. Governor Ron DeSantis and Surgeon General Joseph Ladapo are on a mission to roll back nearly all childhood vaccine mandates. Can you believe it? We could be looking at the first state in modern history with no meaningful school vaccine requirements. But hold on, this isn't just a simple policy change. It's a legal minefield. The legal landscape here has long favored public health. In Jacobson versus Massachusetts, a 1905 case, the Supreme Court upheld smallpox vaccinations as a valid exercise of state power. In Zucht versus King, the court confirmed that schools can exclude unvaccinated children even when there's no outbreak, because prevention itself is part of public safety. More recently, courts have rejected claims that religious exemptions are constitutionally required, noting in Phillips versus City of New York that states can put public health ahead of individual objections. Florida's effort flies in the face of this precedent, but because the state is rolling back mandates rather than imposing them, the legal fight will be different. Historically, parents challenged vaccine rules claiming their liberty was being restricted. Now, the lawsuits are likely to come from the opposite direction. Parents who want mandates preserved to protect vulnerable children. Parents of immunocompromised kids, children undergoing cancer treatment, or those with disabilities will argue that dismantling vaccine protections denies their children equal access to safe education. Under federal disability law, schools must provide a safe and accessible learning environment. DeSantis is framing the abolishment of childhood vaccine mandates as a matter of parental rights. But is that really the right approach? What about the rights of immunocompromised children who could be at risk? Are we really willing to gamble with their safety for the sake of freedom? If classrooms are open to unvaccinated children, parents may claim that the state has effectively forced medically fragile students into homeschooling, segregated programs, or constant health risks. These cases could invoke the Americans with Disabilities Act and Section 504 of the Rehabilitation Act, which require public schools to make reasonable accommodations and prevent discrimination. Plaintiffs could argue that eliminating vaccine mandates isn't just a neutral policy change. It actively creates a hostile, unsafe environment for children who rely on herd immunity. Courts would then face a clash between parental choice on one side and disability rights on the other. That flips the usual script of vaccine litigation, and it could put judges in uncharted territory. Florida, for its part, will argue that the Constitution doesn't obligate states to impose vaccine mandates. They'll frame the rollback as expanding parental rights, insisting that families, not government, should decide what goes into their children's bodies. But the counterpoint is powerful. One family's choice not to vaccinate can impose very real risks on another family's immunocompromised child. And when that risk affects a child's ability to safely attend school, it transforms from a private decision into a public rights issue. And let's talk about the practical impact. Florida has more than 3 million school-age children. If vaccine mandates disappear, vaccination rates already slipping will fall faster. Outbreaks of measles, whooping cough, and other preventable diseases could sweep through schools, especially harming children too young or too sick to be vaccinated. Teachers and administrators will also be caught in the crossfire, struggling to balance parental demands with public health risks. Parents may withdraw kids from public schools, accelerating inequality between wealthy families who can seek private solutions and poorer families who cannot. And the ripple effects won't stop at Florida's borders. States like California, Oregon, and Washington are already signaling they will hold firm to mandates, but if Florida succeeds, others may follow its lead. The result could be a patchwork America, some states maintaining herd immunity, others becoming hotspots for outbreaks. That would weaken the country's ability to manage preventable diseases nationally. The Supreme Court has consistently upheld states' authority to require vaccines. But what it hasn't had to decide is whether a state can dismantle them entirely. The stakes are sky high. If Florida's plan survives, it could mark a turning point where collective public health obligations are replaced by individual choice, even if that choice exposes other children to serious harm. The legal precedent of Jacobson and Zucht says the state can protect children. The open question now is whether Florida will still be willing to do so. So what do you think? Is Florida making a bold move for parental rights, or are they risking the safety of children? Drop your thoughts in the comments below, and don't forget to like and subscribe for more thought-provoking content. Until next time, stay informed and stay safe.